I know that I've been standing in front of you for a long time in my life, and I can't justify that. I am an addict, and I understand that, and I do need help. I understand people don't think that I'm the person that.
One, for tampering with evidence. Two, I'm sorry, second, for a assault resist destructive police officer. A charge of delivery of the controlled substance methamphetamine and bringing contraband into a jail. All have a fourth habitual felony enhancement potential. All right, let's take a look here. Mr. Ringstrom, any objections to PSI in the older file 3614?
No, Your Honor.
Mr. Johnson?
No, Your Honor.
All right. Mr. Ringstrom, now looking at 3619, any amendments, corrections, or objections to make to any of the contents contained therein?
No, Your Honor.
Mr. Johnson?
Yes, Your Honor.
All right, let's go. What we got?
Beginning with the charge of tampering with evidence,
Mhm.
14 is scored at 10 points for being the leader of a multi-offender situation.
Mhm.
I believe that sentencing offense just had one offender, my client, Your Honor. We believe that should be scored at 0.
Okay.
Court heard the testimony that she flushed alleged narcotics down on the toilet. She was the only person that did that.
I agree.
Thanks, sir.
We're going to change that scoring for that count one, tampering with evidence. We're going to score OV 14 from 10 down to 0. That changes the OV level from 35 to 25. Before I go over any adjustments to the guidelines, Mr. Johnson, any further corrections on that guideline scoring?
Yes, Your Honor. Also on that offense, OB 19 is scored at 25 points for threatening the security of the administration. Court heard the trial. No force was used here. I don't see how destroying something that wasn't supposed to be in the jail in the first place threatened the security of the penal institution. She did exactly what law enforcement would have done if they had collected it, got it out of here.
Mr. Ringstrom?
Well, Your Honor, certainly something was flushed, obviously. We know what our belief was it was flushed. Nobody at that time knew what was being flushed down the toilet. Nobody knew anything. All of this stuff, for all we knew, it could have been a bomb. I don't know. I'm just saying that realistically, her actions did, while being incarcerated, while doing what she did affect the jail at that time. And jail had to shut down. Jail had to do lots of searches and everything as a result of that. So
The court in part will grant the objection. I'm going to reduce OB 19, which is currently scored at 25 points, to 10 points. I believe that it interferes with the administration of justice, but I think the flushing it did not necessarily threaten the security of the institution. So the court again reduces that by 15 points. We're now down to 10 points for OB 19, and that's going to take us to a total of 10 points. And that should have an impact on the guidelines. So let me take a quick look. This is on the F grid, so it may. Yeah, it does. All right. So, and it does. We are now down to OV level 2, and that takes us to 12 to 20, or actually 48, 12 to 48 if there's a fourth tab within the discretion of the court. All right, Mr. Johnson.
Yeah, on the police officer assaulting the obstruction charge.
Yep.
Only offense variable scored is OB 19. And it's essentially the same argument that this was not a physical resisting. The testimony was she was told not to flush the toilet.
Hold on. I'm sorry. I didn't mean to stop your thunder. I guess I did need to. Mr. Ringstrom, I'm likely to score it down to 10 points again.
people would be making the same argument too. So
I'll go ahead and amend that scoring of OB 19 from 25 to 10 points. That gives us a total OV of 10 points, and that is on a Class G grid. It doesn't have too many choices, so it's probably, it does. It changes it just a bit. So it changes it from a 7 to 46. Well, it doesn't much, but 5 to 46. I still think that's a good objection. Thank you. Anything else, Mr. Johnson?
Yes, Your Honor. On the, and it's the same argument, Your Honor, on the delivery, manufacture of methamphetamine charge. OB-14 is scored as being a leader in a multi-offender situation. The sentencing offense here is delivery. She was the only person accused or convicted of delivery. Now, there were some accusations that other people may have possessed, but that's a different charge. And so we don't think that OB-14 should be scored at 10 points.
Mr. Ringstrom?
I absolutely disagree with that, Your Honor. In order to be able to have a delivery, you have to have a recipient also. There was two people that were definitely involved. She obviously was the leader in that situation because she was the one who wound up doing the actual delivering as well.
All right, thank you. One moment. Seems like I remember seeing a reference in the bench book. One moment. Yeah, this is what I recall. The court denies that challenge as to offense variable 14. The court specifically does based upon the case of People versus Dickinson, Dickinson. That was a Michigan Court of Appeals decision, 321 Mich. at page 1, and specifically at page 23. This was a 2017 decision. And because it has, the defendant takes it from one person, brings it into the jail and transfers it to another person, it allows the court to score it as a leader. Therefore, the court denies that challenge. Mr. Johnson, next.
Your Honor, we'd also be challenging offense variable 25 on that.
Oh, you mean 19?
As he has 19 to 25 points. And we will be relying essentially on People v. Dickens, 509 Mich. 170, 2022 case. People v. Hines, docket number 363151, 2025 case, in which they talk about hypothetical threats not being enough to score 25 points for the threatening the security of a penal institution. And now the Dixon case did involve a cell phone and required the court to find how the cell phone or use of the cell phone actually threatened a penal institution. Here, my client was convicted of having something in the jail that wasn't supposed to be there and, delivering to another person. But no one was injured, no fights broke out, no emergency response needs to come for any overdose. It was very, was believed to be a small amount, a point of methamphetamine, Your Honor. So although, she did have something, was convicted of having something in the jail that she was not supposed to have, we don't think that it created a threat to the safety of the penal institution.
Thank you. Mr. Ringstrom.
She brought meth into the jail. She delivered that meth. I don't think there's any hypothetical threat here at this point in time. Clearly, having drugs in the jail can be a threat to the penal institution. They had to wind up shutting down jail, basically doing a search of everybody. They had to remove inmates to do testing and all that stuff from it. I don't see where there is no hypothetical threat to the penal institution. It was a threat by them having the meth brought into the jail.
All right, thank you. Well, once again, in the same case that the court referenced earlier, which is People versus Dickinson, the 321 Mich. at page 1, 2017, is actually directly on point. The same objection was raised there, and the Court of Appeals determined that the trial court properly scored it at 25 points, noting that the introduction and delivery of a controlled substance in a confinement facility, such as a jail or prison, does threaten the security of guards, the health of the other people that are there, and I mean the defendants, post, pre-trial, other employees that are working at the jail. And so again, the court rests on that decision, People versus Dickinson, and denies that challenge to OB-19. Thank you. Next, Mr. Johnson.
For the record, same challenge to possessing contraband, same argument.
Then I understand that argument. I think it's a good argument to raise to preserve, however, based upon the same case law referenced by the court a moment ago. The court denies that challenge for offense variable 19 on that fourth count. Thank you. Any other corrections or amendments, Mr. Johnson, anywhere else in that particular PSI?
No, sir, Your Honor.
Thank you. Mr. Ringstrom.
Yes, Your Honor. There's three different types of punishment, as this court is aware of. One were for rehabilitation. When this court goes through this criminal history, which I know this court does, I believe the court will see that there is no rehabilitation for Molly White at this point in time. In fact, she seems to think that she's above the law, and most of the times with the criminal history as is. But the second one would be protection of society as a whole, which, again, going through her criminal history, you'll see that she does have an awful lot of thefts and drug crimes. She is a drug dealer. I believe that the court sat through both of the trials, heard the testimony of Tiffany Jacobson, which I think supports the fact that she's a drug dealer. And certainly these charges, as stated, shows that she is a drug dealer. So I do believe the society needs protection from her. The biggest one is deterrence. So many times when we have drug cases and things like that, unfortunately, guidelines would say, oh, maybe just rehab, maybe a slap on the wrist, maybe a little bit of prison time. In this particular case, we're dealing with high guidelines. And I think that for deterrence purposes, she does need to be able to go away for a long time also. I think that we need to be able to set an example that if you mess with drugs, if you mess with our jail system, this is what could happen to you at this point. The guidelines are the way they are. Recommendations for 15 years. I think that Molly White has deserved at least the 15 years, if not more. And because these crimes did happen in a jail, I think that the court should consider consecutive sentencing as well.
Your Honor, my client deserves to go to prison. We don't concede that. I mean, we concede that, we don't argue that. The issue here is what is a fair punishment? And the prosecution, the first statement about Ms. White is that she's a drug dealer. So was I. I sat on a college campus with a marijuana joint before marijuana was legal, smoked it, and passed it to somebody else. I delivered marijuana. That was a crime. That was delivery. I didn't make any money from that transaction. And I think courts should make a distinction between for-profit dealers that traffic narcotics into a community and make their living selling narcotics to particular people, and users who trade in narcotics for other narcotics supplies, or in this case, clean urine. Ms. White did not make any money from this transaction here, but she did engage in what I will admit is one of the cardinal sins in the criminal justice system. She committed a crime while she was in jail, trying to resolve accusations of another crime. And, that is disrespectful to the court, it's disrespectful to the law, and it thumbs just at authority. But the court heard the testimony. A lot of people think that she was high or thought that she was high or under the influence when she engaged in that behavior. Ms. White sits here, today, with forced sobriety, and realizes how she has sacrificed a good part of her life to drug use, and is going to sacrifice some other good part of time in her life away from her children because of her drug use. I cannot sit here and justify anybody having 15 felony convictions. I'm not even going to get into the misdemeanors. But she's going to jail, y'all. She's going to prison. We understand. But for her level of involvement, the small amount of methamphetamine that we're talking about, I couldn't even do the math. Assuming that the prosecutor's theory was right, and she snuck an 8-ball, 3.5, ounces into, 3.5 grams into the jail. I couldn't even do the math on how many days she's going to get there's too many numbers behind the decimal point to do the math per number. So for an individual who is not a for-profit dealer, for an individual who that wasn't maintaining a dangerous meth house that was emitting gas into the environment, that had a fire risk for an individual who may have been high and suffering from the effects of narcotics dependency at the time she committed the crime, I'd ask the court to sentence her to 9 years in the Michigan Department of Corrections. That is almost a decade. That is what you would see for violent offenders. That, I believe, takes into consideration the harm she did to herself, the harm she caused or could have caused to other people had that methamphetamine been laced with fentanyl. It takes into account, the numerous felony convictions she's had. It takes into account the fact that she did this while in custody, Your Honor. I think that's fair, Your Honor. Had she been, like some of my other clients, maybe downstate, and she had a pocket full of money, and there was a search warrant, and there was a big, local task force investigation, maybe we'd be having a different conversation, Your Honor. But I think 9 years is fair. And we'd ask for a concurrent sentence on all charges, and we'd ask for 12 months on the first file, Your Honor, the possession file, and close that file out.
Thank you. Ms. White? If you wish to say it, now's the time.
I know that I've been standing in front of you for a long time in my life, and I can't justify that. I am an addict, and I understand that, and I do need help. I understand people don't think that I'm the person that they think that I am. I've made mistakes, and I own up to them. I don't try to take other people down with me. That's my own life, and I don't even have excuses for that. The only thing I can ask is for I don't even know how to say it, a chance to come out of here. And I understand prison's going to happen. Understood. Like, I'm still a mom and I still have custody of my daughter, yes. And I know that I can't change anything. However, I can only ask for, even doing a prison sentence, that I still understand and I get help while I'm in there as well.
Thank you, Ms. White. The court sentences the defendant to a prison term of 180 to 240 months, 239 days of credit. These all run concurrent once again with each other and with the two files. The court elects not again to sentence consecutively.